abusuya like video share mo be fufuo na ono so enya bi enhwe na lawyer Nana Baffour de atudwa se ene Sedinam tamaklo a aban ahyede aye kuntuna ase na watimi agya no de no amanafa ne ho adie no appeal a Attorney General Dominic Ayine se okwakoye no ye atrosem wudurada sem sebisebio ye mfuturo bi keke ena opese otu edigu Ghana fo ani a chese ni kwanse obia agye ne die nyina ne se ohwe nsem a akoso ewo appeal court a yetimi abo sa nsem ni nyina etimi etu aguo na chese odwene ho bia onti ase ankyiremu a lawyer Nana Baffour de abafa sa nsem ho enya asem keto akra yengibre na yenkotie bie.
Sometimes evidence may even be relevant, but it may not be admissible in court, right? It may also not be admissible for other considerations, such as public policy, and also sometimes to ensure that the trial, is not dragged. There are various considerations that may also go into the admissibility of evidence. And so I want people to appreciate that when it is said that the prosecution provided evidence, it is not just documentary or material evidence, but also somebody coming to mount the witness box to say that I saw this.
And the person being cross-examined.
And when the person is cross-examined, then the rules of evidence will be kicking in. So, for instance, on a material fact, if I don't challenge you on a material fact, there is an implied admission.
So material facts is that I was at Metro TV at 8:30. So and you don't challenge that.
So let me use
the Sedina situation. Yes, correct.
So when you look at this case, the prosecution had charged Sedina for stealing an amount of 500,000 cedis, being money which was transferred from Maslock to Obatampa Microfinance.
An investment.
Sort of something. And Awuah, my respected brother Awuah would
give us more details.
So let me
go on. Yeah.
Now, to prove this case, the prosecution produced a representative of Obatampa. A representative of Obatampa, the company or the entity that is said to have received the money. Now, there's one fact which was not in dispute. The fact which was not in dispute is the fact that Obatampa has received the money. What was in issue was whether or not the money had been paid to Sedina. That was what
the return money.
The return of the money.
So the story is that she tried to invest with Obatampa and she didn't, or Maslock didn't like the terms of the investment. So they said, bring our money back. And the circumstances of the return, as we are told, is that she wanted it in cash and she received it in an obscure place in Bachona Total in cash. This is the story. How did you want the Court of Appeal to evaluate this, and what did they do wrong?
So, when you look at the High Court judgment, the court said that a representative of Obatampa had come to court to testify. At that moment, there couldn't have been a better witness in this matter other than a person from Obatampa, the entity that returned the money to Sedina. There couldn't have been anybody better than that in terms of evidence, because they had felt it, they had seen it, they had heard it, they had experienced it in a nutshell. And so if you want quality evidence, that is quality evidence for you, a representative from Obatampa. And this representative comes to testify. According to the High Court, right, this evidence was not challenged.
The evidence that what?
The evidence that they had, Obatampa had returned the money to Sedina.
In cash
at Bachona Total. Right? These are facts which he came to testify to. And that is evidence. This evidence, according to the High Court's account, was never challenged. This is the High Court's account.
Okay.
Now, at the Court of Appeal, right, the fact that this evidence was not challenged was not stated. And therefore, we don't get to see whether or not the High Court was wrong on this matter. On saying that the testimony of Obatampa's representative, as far as the return of the 500,000 cedis to Sedina, which she kept to herself, and not return to Maslock, right, was concerned, this aspect of Obatampe's witness testimony, the High Court said was not challenged. The effect of it is an implied admission. We were expecting that for the purposes of evaluation of evidence, the Court of Appeal would have said, contrary to what the High Court has stated, the evidence was challenged.
Wait, but so if the evidence was not challenged, then what they were presenting to the High Court was that Sedina had appropriated or misappropriated the cash.
So to the extent that,
and therefore the charge of stealing will lie.
So to the extent that it wasn't challenged, the return of the money to Sedina was no longer in dispute.
I've heard NDC opinion say that there was a letter Sedina wrote subsequent to that, writing to Obatampa to claim the investment, and therefore, if she had received money, she wouldn't have authored a letter to claim the investment.
I'll come there.
All right.
So at the Court of Appeal, the Court of Appeal then relies on a receipt, right? Obatampa's representative tendered a receipt, which is a written acknowledgement by Sedina that she had received the money. Cash.
Okay.
She had received
I understand that was a photocopy.
It doesn't matter.
It doesn't matter in
if
evidence.
If you can explain why the original is not available, the court will admit a photocopy.
That explanation, can it be cross-examined?
Yes, of course.
Was it cross-examined?
The judgment doesn't capture, but the fact of the matter is that at the point, let me tell you where it becomes relevant, whether or not it should be admitted. It is at the point where it is being tendered. So if at the point where it is being tendered, you challenge it, court receives argument of your objection to the document, and the court overrules it, and it goes in, you can choose to cross-examine on the authenticity of it.
Also, that receipt was admitted in evidence.
Was admitted in evidence.
Like this is the receipt that shows that you have collected 500,000 cedis in cash.
The famous Exhibit A. Now, so Obatampe's witness representative did not only speak to the refund of the money or the return of the money to Sedina. The representative also proceeded to tender Exhibit A as evidence of Sedina acknowledging receipt of the money.
Okay.
Now, at the Court of Appeal, the Court of Appeal Court of Appeal actually impugned the evidence of the Exhibit A on the basis that when you look at Sedina's written statement to Yoko, or call it the police, she had raised doubt about the credibility of the notes of the receipt, right? Even though she says that this receipt, this signature looks like mine, but I cannot vouch for the authenticity of this document.
This is something she wrote to Yoko during the investigations.
During the investigation.
Was she given the opportunity in court to actually look at it and then say something about it?
From the judgment, the judgment doesn't account for whether or not the lawyer cross-examined the
Sedina herself was not present.
No.
But her lawyers were there.
Lawyers were there.
Okay.
So the judgment, the two judgments, the High Court and the Court of Appeal. But let me explain to you why, in my view, the Court of Appeal erred in relying on that written statement.
Hold it there. So the Court of Appeal relied on Sedina's police statement to deny the 500,000 CD.
Okay. Of the statement written by Sedina to the police, the court should have done more by way of examination of the Exhibit A, which is the letter acknowledging receipt of the 500,000.
Like a forensic something?
But I disagree with them.
Okay,
and I explain to you why.
Yeah.
You see, Sedina's statement to the police was tendered by the prosecution. It was not tendered by the prosecution to say that we believe that it is true. It was tendered by the prosecution to say that we have received this information from Sedina. At that point, it's hearsay evidence. You need Sedina to go into the witness box, right, to be cross-examined on the veracity of it. In the absence of that, you cannot rely on it to impugn evidence that has gone through the fire of cross-examination.
Oh, that's interesting. So that the evidence of she brought 500,000, said she doesn't want it anymore, And so she said we should return the money. We tried to return the money in check. She said she wanted cash. We duly delivered the cash to her at Bachano Total in her car. If Maslog doesn't have the money, then the money is with Sedina.
Yes.
We finished our work and we gave her a receipt.
Yes.
You are saying that that body of evidence, apart from perhaps being also on a document to the IYOKO, was explained in court. And there was opportunity for cross-examination. At the end of it, the High Court felt that this evidence should be admitted. In coming to their decision, the High Court judge felt that based on this evidence, Sedina was responsible for the 500,000.
Exactly.
And therefore, the charge of stealing will lie.
That's right.
But the Court of Appeal says that once the matter came to court, because Sedina had ever written before
to the police
that I'm not sure about this signature, that the High Court should have done something more.
That's right.
To make a determination that this receipt was authentic.
That's right.
And you are saying that the High Court was giving too much burden to the prosecution.
Exactly. No, I'm saying that the Court of Appeal,
the Court of Appeal,
should not have relied on that document.
They should rather have relied on the one that was given in court, upon which there was cross-examination.
Exactly.
Rather than the one that was written, where there was no real test.
Under the law of evidence, we call such evidence the person that gave such a statement the declarant. The declarant. You know, he's a declarant, she's a declarant of hearsay evidence, right? Because it's been tendered on her behalf. It's something that was not given in court. Now, the declarant must be available to be cross-examined, okay? So that we can confirm through the fire of cross-examination whether or not what she's actually saying to the police, okay, is true. Otherwise, Paul, this is the simplest.
But if she was not available, should we hold that against her?
She had the opportunity. She just chose not to take it. It is not anybody's fault.
So that should be held against her?
It should be held against her. But look, it's a very simple matter. Let me break it down. Now, if the court were to say that we rely on statements given to the police, then nobody should be in court to testify.
Oh, I get your point.
Are you getting me?
Yeah.
Now, if the court were to say that we are going to rely on statements given by the police,
even if they don't come to court,
so
police call me, I write anything, and I say I wasn't in Ghana and blah blah blah. It's not tested.
Then we shouldn't come.
Then
to court.
That is enough to take me out.
Exactly.
Oh, I get your point.
Exactly.
Then that will be very easy. We can't convict anyone.
So with all humility,
yeah,
you see what I'm talking about.
I now see it.
Police invites me, Baffour come, I go. And then I give my testimony. Oh, an allegation has been made against you. A complaint has been made against you for stealing 1 million cedis, right? Then I give a statement. I didn't steal 1 million cedis, full stop.
I have nothing to do with it.
I have nothing to do with it. I'm supposed to come to court. I don't come to court. Then the court will say, in view of the statement I gave to the police that I did not steal 1 million cedis, I'm not guilty.
Okay, but let me still do the NDC work.
You have the NDC work.
The NDC work is that this document of Sedina is there. Subsequent to that, Sedina in her corporate capacity authored a letter to Obatampa that where is our investment?
Good. So that is evidence of the dishonesty. That is actually evidence of dishonesty on her part. Now we've been able to establish that there's no dispute. Because there was, from the judgment, there was no challenge that she received the money, right? And so there's an implied admission. So that fact, we've crossed the bridge of whether or not the money was returned to her. We've crossed it. Now we are moving to whether or not it was dishonest. The dishonesty lies in the fact that even after receiving the money, she was leading everybody on to think that she had not received the money, and so she was writing letters to make demands. Now, in the witness box, the Obatampa representative was challenged that why were you receiving these letters in spite of your claim of refund? Then the gentleman says, I sent her a WhatsApp message saying that this I'm not supposed to be responsible for because I've returned the money to you, right? Good. Now, this part of the evidence, people think that in the absence of the WhatsApp messages in court cannot be given the necessary weight. I dare to submit that that is not correct.
He said WhatsApp messages. He didn't show it.
He didn't show it. And people might think that in the So you say, okay.
That's difficult to swallow.
That is difficult.
Because anybody can come and say, like the point, anybody can come and say, I sent him WhatsApp messages. I sent him WhatsApp messages.
So when you go into the witness box, you are giving oral testimony.
Yeah.
That testimony, if I don't challenge it, there's no burden on you to produce more.
Okay, that's correct.
Now, when you look at the Court of Appeal decision, there is no challenge of that
on the WhatsApp message matter.
On the WhatsApp message matter.
Okay.
Look, this is somebody who has gone into the witness box to testify. In going into the witness box, you are not likely to know that this is what is going to be demanded of me. This is not what is going to be required of me. And so the prosecution are likely to say that, you know what, this is all we are presenting to establish our case of stealing against this person. These issues that may come up during cross-examination, not everything is anticipated. And so in the course of it, based on the developments, you may then decide that I need to augment the previous evidence that I've made available, or I just need to hold back. Because when you're a lawyer, you're also a strategist, and that's the beauty of litigation. If you're a litigation lawyer, your antenna must be sharp. It must work at all times. You must be picking things that you must deal with within a split second. And so if this gentleman goes into the witness box and says that, yes, why were you receiving demands from Sedina and Maslock if indeed you had returned the money? And she says, no, I even sent her messages to the effect that, look, why are you sending me messages even though I've returned the money? And you as a lawyer, defense counsel, if you don't challenge the person on this by saying, I suggest to you that you never, ever received any WhatsApp message, there's no burden on the prosecution to produce more. That is...
Are you suggesting that defense lawyers did a bad job?
That is not what I'm suggesting. I'm only explaining to your viewers to make a decision. I can't...
Okay, so on this 500,000, you are saying that you don't see how the Court of Appeal was able to acquit Sedina.
On the basis of what has been given. And I'll give you an example. When you go to the court's, evaluation of the charge of sensitization, right? On the issue of sensitization, you discover that Yoko tendered statements given by 3 regional officers. The court simply said that because the regional officers were not in court to testify, it cannot rely on those statements.
Oh, that's interesting. So for Sedina, the court says she gave a statement and we are relying on it.
That's right.
For the Iyoko officers who were part of the prosecution, the court said, yes, we've seen their statement, but why didn't they come to court to testify?
For the regional officers of Maslock,
who were out of Accra.
They had given statements to Iyoko. The investigator comes to court. As part of the exhibits that he tenders
those statements.
The court said that because the declarants were not in court, it's hearsay evidence and they cannot rely on it. And I agree with them. In the same way, in the same token, that is why I disagree with the court impugning the testimony of Obatampa's representatives in court on account of Sedina's statement that he had given to Yoko.
Very straightforward. For Sedina, she gave a statement. She wasn't there. She wasn't there to challenge it or to give further evidence of it.
Yeah.
It's okay. We hold the statement she gave. For 3 regional officers, they gave a statement. It was tendered through the chief investigator.
That's right.
Because they were not in court, Court of Appeal says, I can't deal with it.
Exactly.
And that's what you're expressing.
And that's what I'm expressing. And so now you see the parallel. Now, even with the sensitization, okay, the auditor was in court to testify, and the Court of Appeal decision acknowledges the presence of the auditor in court to testify.
Auditor of what?
The auditor who audited the books of Maslock and uncovered a lot of these frauds. By the way, let me make this disclaimer. People think that I'm connected to Baffour and Associates who undertook the auditing. If he stands here, I wouldn't know him. Because of the name, we may be related, but I've never met him before. I don't know him. I only operate a law firm. I don't operate an auditing firm. So Baffour and Associates had audited the account of Maslock. On the back of that account, they had drawn certain conclusions that, for instance, the sensitization of the over 80,000 people never took place. Right? Now,
and they were in court?
They were in court. They went to testify.
I see.
They went to testify.
Testify to their report.
Testify to their report.
Cross-examination happened.
The court, from the judgment, did not do any evaluation of that.
The Court of Appeal.
The Court of Appeal. And that for me was also problematic. And that is why I said that the court rather concentrated too much on what they, in their view, ought to have been done by the prosecutors in this case, instead of focusing on what was before them. Because if, for instance, the auditor had not been challenged, right, then his findings would have gone in as an unimpugned testimony, which would have been enough basis to convict Sedina.
Are you going to supply these things to Dominic Ayine?
No,
he said that he's filing an appeal to the Supreme Court. But this will be very important grounds of challenge.
And this is where I am very worried. I'm very worried because the Attorney General, who is the chief legal advisor, had taken a certain position, right? That he thinks that he disagrees with the Court of Appeal.
And that he's going to appeal to the Supreme Court. I'm
definitely sure that the Attorney General did not come to this decision lightly. Don't forget that this Attorney General, Dr. Dominic Ayine, has been very vocal on things that he thinks, in his view, the former Attorney General, Godfrey Dame, had not done right.
Yes.
Including particularly the Saglemi prosecution.
And many others.
But he never, for once, said that Mr. Godfrey Dame had not prosecuted the case of Sedina properly.
So what you are saying is that Dominic Ayine is given to being critical of Godfrey Dame.
That's right.
If, therefore, there was something in this document, in this process, that he would have noted that Godfrey Dame did wrong, he would have said it very quickly. To the extent that he hasn't said that, and he says that he's going on appeal, we should assume that the Attorney General is unhappy with the Court of Appeal decision.
He's unhappy because he knows more than we all do.
Why does that make you worried?
I'm worried because of the contrary commentary which is being run by some surrogates of the NDC.
Contrary commentary?
No, for instance, my own good friend and brother, Eduji Tamaklo, has taken a very feisty position.
He's been critical of Godfrey Dame's work, actually, directly. Yes. Right?
Vomaho, who is part of the NDC clerk, even though my brother...
he's a civil society NDC.
No, but has he admitted?
No, he doesn't need to.
But
I have a letter to read to him tonight, but go on, yes. Okay, however you want to describe him.
Mr. Inusa Fuseni,
former member of parliament and NDC minister.
They are now all in defense of Sedina.
Whereas the Attorney General is saying something else.
Exactly. It makes me a part, it makes a part of me becomes predisposed to the thought that it is not sincere.
What is not sincere?
The quest to appeal against this decision is...
but you have to give that time. If they file the appeal and they file the processes, we will see it. We will know what arguments they are making in the Supreme Court.
So I shouldn't be too quick to mistrust.
I think you shouldn't be.
Okay,
I think you should trust Dominic Ayine on this one.
Okay.
As you yourself have said, Dominic Ayine has been speaking. If really he has something to say about Godfrey Dame, he would have said it.
In respect of Sedina.
In respect of Sedina, he would
have
said it.
Because he said so much about him already.
He said a whole lot about him.
Good.
So we should agree that when the Attorney General says that I'm appealing against this decision, I think the NDC lawyers are doing their own thing. I mean, and they have to do that sometimes. Our politics becomes like that. So that defend who is your person.
So they defend Sedina.
And attack somebody who is not your person.
So they defend Sedina.
Yes, to mobilize the party base.
Okay.
And let the party base feel that it's not true that Sedina has done anything, but it's the MPP people who are making it look like that. But the Attorney General is standing in the middle. Sure. And we have to have confidence in Article 88.
I have no doubt. No, I have confidence in Attorney General. But you see, sometimes you should also trust with a bit of allowance.
I agree.
And so I'm not wrong in creating that allowance because of the circumstances.
You feel, there's another question, slightly unrelated. You feel bad for, say, an Hearsay, a lady who was doing so well at the court and now they take this judgment and blah, 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 blah.
Look, Justice Hearsay Buchi is one of the best judges we have.
I've heard that so many times. I've never seen her before, but I've heard that all the time.
Stellar prosecutor, stellar.
Oh, she was at the Ages department.
She was a prosecutor herself.
Oh, so she understands these
all
things.
All those who know Justice Efia Sewaboche as a prosecutor in Kumasi will tell you that what people are saying about her, they don't actually know what they are saying about her.
Oh, I see. She was in the Ashanti region.
Yes. Justice Efia Sewaboche in the courtroom. In fact, she's one of the judges that I have been betting on to go to the Supreme Court.
She's a Court of Appeal judge
She's
now.
a Court of Appeal judge. Yeah. And I've been betting on her.
She missed the boats though. She was not in the list.
I've been betting on her that she'll become a very great Supreme Court judge.
When it comes to criminal matters?
She's so dynamic. She's so, look, Paul, I love the law. And I love judges who allow you to practice the law.
Like Sir Dennis and Kulendi.
Like Sir Dennis, Justice Kulendi, even Justice Puaman. I love judges who love their work and they will give you the opportunity to espouse the law.
Efia Sewa is one of them.
Oh, Efia Sewa is a solid judge. Look, Efia Sewa is a solid judge.
We'll leave it here, Baffour. Thank you so much.